Welcome everyone to the second session of Anarchy and Law Reading Group. Last time we discussed the very basics of how arbitration mechanisms in a free market could replace a centralized body of law, that is the state. We also criticized the state's justice system on the problem of calculation. In this section, we'll be concentrating more on what justice is and how and the topic of crime prevention and how it is related to public property. In the Andrew, I think I'm getting a feedback from you.
Okay, hold on. I'll get some headphones.
This is a, where is this feedback coming from? Is anybody else getting the double voice? I mean, like what I'm saying is getting repeated like after quite a few minutes.
No, not really.
It's happening for me only. Why? Oh, sorry. So that YouTube link was open. Sorry. Sorry about that. Andrew, it was not you. Sorry. Another tab that YouTube link was open that I shared. Anyway, so yeah, so in the discussion group, I asked what is the difference between libertarianism and basically market anarchism, and I did not get any satisfactory reply. But there is a difference. They are not the same thing. You see, when we're talking about justice, we are leaving the realm of libertarianism as Rothbard saw it and entering the realm of market anarchism. Libertarianism is concerned only with the ethical use of force in society. It has formulated what it considers to be the most consistent principle in this regard, that which we call the non-aggression principle. As the saying goes, my right to swing my fist ends where your nose begins. If I really punch you, the libertarian logic will say that it was ethically wrong to do so. Most people agree to this, but libertarians use this analogy and apply it everywhere in every aspect of our lives. But libertarianism doesn't talk about justice. It doesn't say how much about. It doesn't say much about what is justice and after its ethics has been violated. Using libertarian principle, you can conclude that defensive force is ethical, and you can also conclude that taking restitution from your aggressor is also ethical. But the principle itself doesn't say how much of restitution amount would be just. If you steal 10 rupees from me, are you now under lakhs of rupees of restitutive debt? Am I going to be demanding that much restitution, and will that be considered justice? Market anarchism is the idea that market institutions can handle these spheres of activities better than governmental institutions. There isn't anything particularly libertarian about it, except that they are consistent with libertarian principles, while the state isn't. But we also saw in the last podcast, David Friedman, he wrote about how these market institutions may even result in laws that are not precisely libertarian. Uh, Libertarians support market anarchism because they consider it to be the best option for protecting people's life, liberty, and property. Sure, it would be amazing to live in a society with no conflict and no one breaks the non-aggression principle, and when they do, they offer restitution themselves. But if such a society existed, there would be no need for arbitrators. Conflicts are bound to exist, and we all have conflicting goals. Many of these goals are mutually exclusive. Market anarchism is basically libertarianism being real. And when we are talking about restitutive justice, we need to understand the economics of it, which is what Morris and Linda Tannehill do in chapter 4 of this book. The system that they describe is almost the same as that we discussed in the last podcast, where we read Rothbard and Friedman. I'll be assuming that you have listened to it. I will also only be talking about the additional insights of these writers in this podcast. So, so let us discuss justice. Is justice the concept of eye for an eye? If so, then what is the difference between justice and revenge? If you think about it, the concept of justice is needed when someone destroys something of yours that you value. That is there is a destruction of property or destruction of value for the concept of justice to be talked about. We can differentiate between justice and revenge by using this concept itself. The Tannehills consider eye for an eye as revenge because it consists of destruction as a reaction to destruction. If you take out my eye, I lose something that I value, and if I take out your eye in return, I would not be doing justice. That would be revenge. There is a net destruction of value in revenge. After revenge, both people are worse off. The criminal has been punished, but the victim's condition has not improved. From the chapter, the present-day penology no longer makes such demands. Instead of an eye or a tooth, it takes the criminal's life via execution, or a part of his life via imprisonment, or his possessions via fines. As can be readily seen, the principal vengeance is the same, and it inevitably results in a compound loss of value, first the victims and then the criminals. Because destroying a value belonging to the criminal does nothing to compensate the innocent victim for his loss, but only causes further destruction, the principle of vengeance ignores and in fact opposes justice. So, end quote. What is justice? Justice would be compensation to the victim in proportion of the value he has lost. Under restitution-based punishment, the criminal is declared to be under debt to the victim. Once declared to be in debt by an unbiased arbiter, force can be used to extract that debt. This way, the criminal is punished and the victim is also compensated. Moreover, we find restitutive-based justice system gives the criminal a chance of rehabilitation as opposed to what the state provides today. State prisons are usually called rehabilitation centers, and their language tends to use that jargon as much as it can, but we can easily find that the opposite is true. Government-run prisons are little more than schools for crime, where young first offenders are caged with hardened criminals, and there is no incentive or opportunity for rehabilitation. Government-run prisons are centered on the concept of revenge rather than justice. The concept of prisons can also be derived from restitution as well. I could not compress this section from the book, so I will just read it out loud. If the aggressor had the money to make his entire reparations payments immediately or could sell enough property to raise the money, he uh, he Andrew can ask a question if you want to ask right now, or like I can if you want to add anything, you can go add right now.
All right. I think the concept of an eye for an eye, tooth for tooth does not resemble what it originally meant. It came from an Old Testament Jewish court tradition, and the
Okay.
basic they didn't actually take eyes and teeth. What it meant was that you can't ask for more recompense than you are due. In other words, if something cost you $100 of theft, you don't have the right to take $1,000 of the other person's property. That was the original meaning of eye for eye
Oh,
and tooth for tooth. And it wasn't intended to be vengeance. It was intended to keep a balance in between the level of the crime and the level of the recompense. And recompense was handed out in these traditional Jewish courts. Just so they put that in.
Yeah, I did not know that. I think the meaning has changed a little. I mean, to from uh, to exactly the literal meaning that taking eye for an eye. But yeah, I think the authors I think are using it in the meaning of revenge, that you destroyed something that I value. I'm going to destroy something, or I'm going to get someone else to destroy something of that you value. So
Yeah, well,
I
yeah.
think the
Well,
authors are using it
that actually,
in this sense rather than
the original sense actually seems to
proportional.
go along with what the author is trying to get at. Instead of being opposed to it, it actually sounds uh, the idea of proportionality of
Yeah,
um,
they talk about
crime
proportionality actually
recompense.
later on,
Yeah,
but yeah.
that was what the original intention was. So I'm sorry, I did mean to interrupt. Please.
No. Just show cam. Actually, I was prepared this to get some discussion started, but like I'll uh, keep on reading unless someone has something to add. They can surely go in and add. So, okay, I'll read from the book now. So the concept of prisons, yeah. So if the aggressor had the money to make his entire reparations payment immediately or sell enough property to raise the money, he would do so and be free and be free to go on his way with no more than a heavy financial loss. Situations of this kind, however, would probably arise because aggression is expensive. Even a small theft or destruction can quickly pile up a fairly large debt when related expenses, secondary payments, and others who suffered because of this victim's loss, costs of defense and arbitration, etc., are taken into account. In a totally free society, men tend to be financially successful according to their merit. Few successful men would desire to commit aggression. Few unsuccessful men could afford to make immediate payments for it. Assuming the aggressor could not make immediate payment of his entire debt, the method used to collect it would depend on the amount involved, the nature of the aggression, the aggressor's past record and present attitude, and any other pertinent variables will be taken into account. Several approaches suggest themselves. If the aggression were not of a violent nature, then the aggressor had a record of trustworthiness, it might be sufficient to leave him free and arrange a regular schedule of payments, just as it would be done for any ordinary debt. If the aggressor could not be trusted to make regular payments, a voluntary agreement could be made between the insurance company, the aggressor, and his employer, whereby the employer would be compensated for deducing the reparations payment from the aggressor's earning each pay period. If the aggressor were unable to find or hold a job because his employers were unwilling to risk hiring him, he might have to seek employment from a company which made a practice of accepting untrustworthy workers from lower than market wages at lower than market wages. If the facts indicated that aggressors was of an untrustworthy or violent nature, he would have to work off his debt while under some degree of confinement. The confinement would be provided by rectification companies, firms specializing in this field, who would maintain debtors' workhouses. The use of term prison is avoided here because of the connotations of value destruction attached to it. The labor of men confined would be furnished to any companies seeking assured sources of labor, either by locating the debtors' workhouses adjacent to their plants or by transporting the debtors to work each day. The debtors would work on jobs for wages, just as would ordinary employees, but the largest part of their earnings would be used to make reparations payment, with most of their rest going for their room and board, maintenance of the premises, guards, etc. To ensure against refusal to work, the reparations payments would be deducted from each pay before room and board costs, so that if the man refused to work, he would not eat, or at most would eat only a minimal diet. There would be varying degrees of confinement to fit various cases. Many debtor workhouses might provide a very minimum amount of security, such as do the few present-day prison farms where inmates are told, there are no fences to keep you here. However, if you run away when you are caught, you will not be allowed to come back here, but you will be sent to a regular prison instead. Such workhouses would give debtor a weekly allowance out of his pay, with opportunities to buy small luxuries or perhaps rent a better room, weekend passes to visit families and friends, and even more extended vacations might be arranged for those who have proved themselves sufficiently trustworthy. Other workhouses would provide facilities of greater security, ranging up to maximum security for individuals who have proved themselves extremely violent and dangerous. A man whose action had forced his confinement in such a workhouse would find himself at a disadvantage in several ways. He would find that he had less liberty, less luxuries, limited job opportunities, and a longer period of confinement, because with more of his earnings spent on guards and security facilities, it would take him longer to pay off his debt. End quote. So, so traditional prisons are improbable in a free society because of a few economic reasons. First is that there is jurisprudential risk involved. Unlike the state police or courts, these private entities have no special privilege or immunity. The concept of immunity does not exist. Every individual in a private law system is responsible for his own action, and this extends to the collective, like this extends to any collective, like a defense agency. An agency will be responsible for incorrect judgment of guilt, and it will be liable for the now victim that it thought it was a criminal. Other agencies would gladly enforce this liability in a competitive environment. Second reason why I think that a free society won't have traditional prison is that they are costly to maintain. The only reason the revenge-based uh, prison system survives is because of tax money. Running a traditional prison isn't exactly profitable business on a free market. The only reason why we have a sort of private prisons currently uh, is because they are paid by the government to provide those prisons. While debtor warehouses can be a profitable business because you're providing a service that even the criminal debtors may want. Criminals who wish to work off their debt and want a fair chance at rehabilitation would easily want the services of a debtor warehouse. While they are working off their debt, they would be paying the warehouse for a variety of services like housing, food, and probably rehabilitation, which may involve 24/7 surveillance and psychiatric treatment, and maybe a certificate in the end, so that he can start building some trust with other members of the society. So because the insurance company would want to recover its losses quickly, it may even spend money on increasing the productivity of the debt worker. The insurance company's desire for speedy repayment would be the debtor's best guarantee against mistreatment. Earning power depends. Earning power of a worker depends on productivity, and productivity depends on the use of mind. But a man who is physically mistreated and mentally abused will be unwilling and even unable to use his mind effectively. A mistreated man is good for little more than uh, brute physical labor, a situation of prohibitively low productivity. It might seem utopian, but it is not unprofitable. Of course, we are talking about a well-developed restitution-based justice system that has the liberty to develop these luxuries like rehabilitation. At the nascent stage of a free society, we may see some primitive form of this system. So, so why does the state not take the path of restitution and instead chooses the eye for an eye kind of system? Uh, this has something to do with the fallacy of crime against society. From the chapter, from I'll read from the chapter. The fallacy is the assumption that society is a living entity and that Therefore, a crime can be committed against it. A society is no more than the sum of all the individual persons of which it is composed. It can have no existence apart from or in contradistinction to those individual persons. A crime is always committed against one or more person. A crime cannot be committed against that amorphous non-entity known as society. Since neither society nor government can have any rational interest in bringing a specific aggressor to justice, who is interested? Obviously the victim, and secondarily those to whom the victim's welfare is a value, such as his family, friends, and business associates. According to the principle of justice, those who have suffered the loss from an aggressive act should be compensated at the aggressor's expense, and therefore it is those who have suffered the loss who have an interest in seeing the aggressor brought to justice. End quote. Okay, so Andrew, you ask, how are labor rates of captive labor force determined? Usual market patterns do not apply. L- Laborer has no real ability to. Uh, I didn't quite get the question, Andrew. Can you like elaborate?
Well, I mean, if you have laborers being forced to pay off a debt they owe, um, how is the labor rate determined? Can't the businesses simply decide that the labor rate is 10 cents a day and
Oh,
nobody,
nobody has
you'll
the
never pay
ability to
it off,
defend
then
him.
you'll basically have an endless
Yeah.
supply of slave labor.
No, but it's actually it's the slightly the other way around. As I tried to explain, debtor workhouses actually have both the insurance company and the debtor as his how to put it, as his customer. So you're asking what will protect a debtor worker.
How does a
Like
worker push
how does
back and
someone
say,
even how does someone even bargain and set a price? Well, how it has been explained in the book is that the aim is not to put worker in a workhouse and make him work. The aim is to declare him under debt, and he would be the punishment for him is not working in a debtor warehouse. The punishment for him is giving those making those payments to the said insurance company. So. So it is his it's like him trying to he will have to end up paying that debt regardless of whether he's in a debtor warehouse or he's working on his own. If he can
so
find.
it's a bargaining
So
between
yes, so
the
it's
company
basically,
hiring and the
and the debtor actually. So
right. So
yeah, so if
basically, the labor has no input to it,
uh, I- bargaining between the company and the what are we talking about?
and the labor. I mean, the company would bargain with the insurance company. Insurance company wants the debt to be paid off as quickly and easily as possible. The people giving the job want, of course, the lowest wage rate possible.
Well,
The negotiation is between these two entities, and the actual labor doesn't have any say in the matter. Is this the way it's being set up?
this is not the way that I saw. Definitely, forced labor would be against the principles of free market. That is not what they advocate. Uh, the responsibility to pay off debt, the debt that the aggressor has created, is on the aggressor. How he pays it back, how he earns it, whether he sells his property, existing possessions, or how he does it is depends upon him. And if he's able to do it, a workhouse will not even be involved. But and if he's able to get a job to work and pay off that debt, and maybe in non-violent, maybe in uh, in cases which are not exactly criminal cases, but violations of contract and such stuff like that. There won't be even need for such a debtor warehouse. In which case the person will have to work off his debt. He'll just have to find a job on the free market somewhere where he could earn. The situation of debtor warehouse actually arises, from what I understand from Tannehill, their writing, is that when the debtor is unable to find a job anywhere, when no employer is willing to employ a particular no employer is willing to employ that particular offender, because he's either a violent offender who has done something that was really heinous, or for some reason no one is really trusting that person, because we find that like criminals usually do have a hard time finding a good job. So it's not that someone is forcibly taking him and putting him in a debtor warehouse and saying to him that you have to work here and nowhere else. What anyone is only doing is that you have to pay this much debt off. How you earn is upon you, and here are these some particular debtor warehouses where you can check yourself in and work on rehabilitation and stuff like that. And basically, so here the debtor, the aggressive, the worker has the option of either checking him into the labor camp, or choosing between multiple the debtor warehouses, or not getting into a debtor warehouse and taking responsibility for himself and finding a job somewhere if he can, to pay off that debt.
Well, then what would stop him from simply just walking away from the warehouse and said, "I'll pay it back later when I feel like it"?
Uh, that what is stopping the same thing that is stopping any other debtor. I mean, the only difference between him and any other debtor is that he has committed a crime. And so what is stopping in the free market, what is stopping me from taking a huge amount of loan from you and simply walking away and saying that, I will pay you later when I feel like it.
Not
So
because you get thrown in jail.
well, yeah, it could get you thrown in jail, or it could, you know, in this kind of system, the force could be used to extract all your property that you have currently,
But if you don't have any,
recover. So if you don't have any, then it becomes a question of putting someone in a debtor warehouse. Yes, and here
and their incentive to work is what exactly?
to pay off the debt. Yeah, I don't.
Well, they don't care about the debt. They wouldn't have incurred it in the
Yeah.
first place.
So if someone has no incentive to work, he'll
They're
be
not going to work. I mean, that's
put
just
in
human
confinement.
nature.
I don't know how it will go. I mean, like people who have given up on society like that, I don't know if there's any way to deal with them. I don't know how the state deals with them by putting them in jail. I'm not sure how the free society would deal with it. I mean, like just
Uh,
putting them in jail and just putting them there.
Actually, if
Anybody?
you don't have anything, you wouldn't get a loan from anyone.
But if you don't care,
I
you
think
already
this
got your
is.
loan.
Yeah, I mean, this is a situation, right, in which a loan is it's a theoretical loan. It's not exactly uh, given. It's a restitutive loan.
I think, anyways, you have to, like a person, a criminal who is, unwilling to pay his debt, you have to use force. So force, the justification of force comes in, like when somebody has violated any other, there is a victim involved. So we have to force the criminal to compensate the victim somehow. So I think even if there are jails or warehouses where criminals are supposed to work, there will be different warehouses. Some warehouses will have certain kind of jobs, and other warehouses might have certain kind of jobs, different labor rates. So I think there will be some kind of salary fixation, and the insurance company and the private police who has the power of arrest are going to put this person in that particular warehouse, and there has to be some kind of force. It cannot be that without.
Ultimately, if like no one is, if the aggressor is just has the attitude that do whatever you want, I'm doing nothing, I'm not following no rules, I'll not be cooperating, I'll be just sitting and doing nothing. Well, in that case, well,
There is
at the end of the day,
really.
I think there's no other alternative. Whether it's the state or some market institution, ultimately, force will be used to extract as much restitution as humanly possible. I mean, he has created a debt, but you can't extract that which he doesn't have. Neither can state nor can a market institution.
Now, I have to ask, I'm sort of new to these ideas, so I'd have to ask just a couple of questions just so it can be clear in my own mind. I hope you don't mind.
Yeah.
One is it says every dispute is between an aggressor and a victim, but there are honest disputes in which there are no aggressors and there are no victims.
Yeah, of course. Yeah.
Where is the borderline between my property and my neighbor's property? They think it's one place, I think it's another. There's no aggressor and victim here, but
Yeah.
we want to know because we want to put up fences, So that's
Yeah.
the dispute. There's no aggressor, there's no victim.
This is the starting point of the paper. I think we'll discuss it in a couple of next podcasts. The justice entrepreneurship in a free market. He
They
talks
just
about
make it's just a statement that a dispute is between a victim.
yeah. So
But you can have disputes that are not between victims and aggressors.
no, but like how you're interpreting is that when you're talking about dispute between the victim and the aggressor, you're assuming you know who the victim and the aggressor is. If you know who the victim and the aggressor is, I don't think there is any matter of arbitration. It's only when the victim is extracting a lot more from the aggressor than would be considered justice is when arbitration starts to come in. So if the matter is already clear, I don't think arbitration would even be involved in a lot of these cases. Arbitration is only involved when the matter is not clear, when the two people cannot sit together and decide what exactly is. If there's an aggressor, it becomes a matter of private defense. If someone is attacking you, you're not going to wait for an arbitrator is not even involved. It's only it will be a matter of private defense. You'll have to defend yourself. Uh, the arbitrator only comes in when there's a dispute between two parties and they are willing to settle. As you said, that there could be disputes, honest disputes between two parties, and the function of an arbitrator does not really change whether it's an honest dispute or if it's not an
Yeah,
honest dispute.
even in the honest dispute, there will be justification, right? Because there will be claims involved. Like I claim this property, and this is
So
what.
even in suppose I have I have a car basically, and you suddenly out of the blue come to me and say, hey, this is my car. You probably stole it from me. So now we have a dispute, and you might not even be a person who is claiming it out of thin air. You might really think that I have your car because my car looks exactly like yours. But the fact is, I think this is my car, and you think that this is your car, and now there's a dispute. And now there needs to be someone needs to go to the bottom of it, find the source of the purchase of this car, and to prove who the car really belongs to. And in such cases, between agencies, there can be a dispute. The proof might not be clear. In such cases, also arbitration would be required. So at the end of arbitration, if it turns out that it was my car and not yours, at the end of the day, neither of us are really aggressors, but the dispute still happened, and the agency still got involved, and so did the arbitrator. So in such a situation, so it's not necessarily we talk about aggressor and victim, but we are assuming that we know that at the end of the dispute there will be an aggressor and there will be a victim, and there isn't. Uh, that is also a possibility. Basically, the aim is peaceful resolution.
See, the other kind of honest dispute would be property disputes where the previous property owner had died. For example, an elder in big family with a lot of relatives staying under one roof, joint families kind of thing. If the owner, who is the current owner, especially it's mostly the elder of the family, if he is dead and his heirs are disputing on the property, like how much who should get and what if one person has done for the family and stuff like that, right? That's a dispute, like who gets what. It's a joint ownership kind of on the property. Or it might be a company where two partners want to split at certain point of time, and they have a dispute of how much share should go to whom and what. Now here we don't have a victim, we don't have an aggressor, but we have a dispute of who gets how much. So even that will go to the arbitrage, and I think they have to claim like why they demand what they are demanding. And again, that I don't think here there will be a use of force, like the dispute will stay open until and unless there is no settlement. So that's the only way I think such kind of disputes will be sorted out. Otherwise, I don't think there will be there has to be jail, or there has to be forceful distribution of wealth or resources. It has to be it has to go on till settlement, I think.
Yeah, it was because in when doing the reading, it seemed that was the definition of a dispute. Whenever there's a dispute, there's an aggressor. And this is just not the case.
Yeah, I mean, because we usually talk about crime, right? So we're automatically putting it in context of crime, because people usually don't have a problem thinking about dispute resolution when neither of us are violent. But people have issues dealing with dispute resolution when one party is obviously the violent criminal. How are we going to survive without the state? And that is where the discussion actually ends up being. So our language has, I think, naturally mirrored that.
I'm not trying to defend the state at all. I'm just trying to understand a little better.
I think the role of arbitrator ultimately comes in when there are conflicting property rights claims. So it could be an honest mistake on both sides, or it could be one person is being dishonest. But in either case, the role of detective agencies and the role of arbitration doesn't really change, because before taking the case, both the detective agencies and the arbitration agencies don't really know whether someone is being honest or dishonest. That is why they have to go through the procedure of the entire court trial.
Another question: how do you deal with loaners? For example, if
Sorry, I didn't get that. What?
How do loaners, people who are off by themselves, people who have no living relatives, no known friends, is it okay to just go up and kill them, because once they're dead, there's nobody to recompense?
One paragraph that I copied from later, and how. So yeah, the question of loaners. So when I reach there, I'll probably have the context in my mind to answer that question. So can we defer it for like a few half an hour?
I'm just trying to get to this definition.
Yeah.
Okay.
So
whenever you feel like it.
So basically, I think the argument is that what if I have no family, no job, no contact, nobody really cares about me, and someone kills me? Who is going to ultimately come and demand justice from me? That question, we get to that question. This has been dealt somewhere later. Shikhar, I have to mute you. There's background noise. Anyway, so I'll move forward. Yeah, Shikhar.
What would be the incentive against? I mean, like there are mafias operating who are hired killers, so that's a much more violent kind of a thing existing. But what I'm asking is, there are people who would have an interest in extending the dispute as much as possible. So, what would be the incentive against maximum extension attempts of disputes? I mean, some underground things like deception agencies kind of might pop up, so that they help the certain wealthier parties who would like to extend the dispute as much as possible.
You're talking about in case of arbitration, or you're talking about in case of mafia? Because if a mafia has truly gone violent, it won't be ready for an arbitration, right? So which of the two are you asking? So you're saying that what if someone wants to prolong the arbitration case? Is that what you're saying? Okay, yeah, so that is also there in my text. I'll just read on when I get there, because actually I've written down the speech, right? So I put all the points I could find and put it. So it's also there. I'll when I get to it, I'll also answer that. So just hang on.
Okay.
Uh, okay, so so I'll continue. Believing that crime has been committed against society rather than some individuals is taking away private responsibility for punishment. When we say that crimes against society are to be punished by the government, we give up all the private responsibility of punishing the criminal. Uh, the aim of the government is primarily not concerned about the victim, because only individuals can show concern and only individuals can act. The motives therefore become political. The government is able to hide its actions behind the immunity of law. What I mean by that is, even though the government claims to follow proper procedure and treat people as innocent until guilty, we find that the reverse is true. If the government arrests you, detains you, or ill treats you, it is not made to submit to an external third party agency and punished for its wrong decisions. You are not compensated for your time in prison, which we now know was an act of kidnapping. On rare occasions, suppose the government does pay you, that money comes from the pockets of the no, comes not from the pockets of aggressors who actually detained you, but from tax. Really, the government is economically the most unaccountable institution. It loses nothing for its bad decisions. This is true for its acts of interference in other sectors of the market. Why would it not be true for its accountability in implementing the law? A private agency, on the other hand, would not dare arrest you or detain you unless it was sure that a disinterested third party would pass judgment in its favor. If a private agency does not have enough evidence to win a case, it won't act, because if it loses the case, it had kidnapped an innocent citizen and must pay restitution to him. Now, I'm not saying that private agencies will make no mistakes, but in a system of private responsibility, therefore, there forms a system of checks and balances that punish bad jurisprudential decisions and rewards the good ones. Such a mechanism is missing for the government. I think one major reason that people have apprehensions against the system of private law is that they are still in the mindset of state justice, that justice can only be provided by someone in permanent authority, that we need a permanent hierarchical structure that is capable of delivering justice. Before understanding private law, this mindset must be abandoned. What market anarchists show is that such a mindset is destructive to the very concept of justice. When people with such mindset analyze a private law society, they immediately imagine corporations with as much immunity as the state. That is not what is being argued here. What is being argued for is equality of authority. If the agency in a private law society detains someone, it is it is not doing so because it has the right to do so. The agency will have to justify its actions just like the rest of us, or be declared a criminal and hunted down. When a state detains someone, it is considered to be a proper procedure. There is little to no physical backlash against the state. The state is immune to external checks and balances. Its notion of innocent until proven guilty is a lie. In reality, justice requires neither presumption. What it requires is private responsibility. If you think someone is guilty of a crime, you must be really sure of the fact before you go ahead and detain him. A guard in a government prison can treat the prisoners as less than animals and never be brought to account for it, because he is protected by his status as a part of policing arm of the government. If a guard in a debtor's workhouse couldn't, but a guard in a debtor's workhouse couldn't hide behind the skirts of a rectification company which employed him. The way the prison guard hides behind the skirts of the government, uh, the debtor workhouses guards would be recognized as an individual responsible for his own actions. If he mistreated a debtor, in his custody, he would be held personally responsible. He couldn't wriggle out of it by putting the blame on the system. We will discuss the concept of private responsibility and entrepreneurship in a free market justice system when we discuss the paper Justice Entrepreneurship in a Free Society. There's more of this on this topic, but I think for now this will suffice. So the mechanism that Morris and Linda Tannehill explain is quite similar to what was discussed in the previous podcast based on the writings of Rothbard and Friedman. So I'm just going to discuss some additional insights. So the Tannehills have a concept of secondary losses. For example, when a man is assaulted and seriously injured, his family may be caused expense as well as anxiety. If he is a key man in his business, his employer or his partners or his company may suffer financial loss. All this destruction of value is a direct result of irrational behavior of the aggressor, and since actions do have consequences, the aggressor has the responsibility of making reparations for these secondary losses as well as the primary loss suffered by the victim. Now, I don't know if this concept gels with the Rothbardian ethics, but one could consider that it is up to the victim to decide how the reparations payments can be distributed. This is one of those times when market can be unpredictable as far as libertarianism is concerned. Whether or not you advocate secondary reparations, they are likely to occur if some conditions are true. Firstly, if the expected reparations payment must be more than the cost of being involved in the litigation. Second, the total amount of reparations which can be collected is limited by the aggressor's ability to pay, and of course the first consideration goes to the victim, so you might not even be able to extract any reparations if you suffered secondary losses. Now, next, let's talk about what would be restitutive amount and what market forces decide the restitutive amount. Rothbard had this notion of double restitution, that the aggressor must not only replace or pay for the damaged property, but also pay an equivalent amount more. This sounds a lot like price fixing and seems quite unlike Rothbard. Market mechanism will have various economic forces deciding the restitution amount, and they need not be double. If in some cases the amount may even be more than double. If suppose I have stolen 10 rupees, which is a small amount. Now, how can such a so now how much of restitution can you demand? Obviously, you cannot demand 1,000 rupees from me, but in certain situations it would be justifiable. What if I was saving those 10 rupees for a business opportunity that I missed because of your theft, and I lost that investment opportunity to earn a lot more? Let us consider a worse situation. What if you were taking a bag full of cash to a hospital to pay for an operation of a relative? If you were robbed by me, it could very well prove fatal to the life of your relative. In such a case, there is no telling how high the restitution amount will be. It certainly would be more than double. The more psychic loss you have suffered, higher the restitutive amount you're going to demand. There is no way to directly measure your psychic cost. In many situations, it might even be considered philosophically unmeasurable. If you lose something of irreplaceable value, you might even demand revenge instead of justice. The market, being amoral, would probably provide it if there is enough demand for it. However, justice requires the aggressor to compensate the victim insofar as humanly possible, and replacing something of irreplaceable value is impossible. Certainly, we can't expect justice system to do the impossible. So this was one side of the market forces. People who want justice would demand restitution payments, and they will demand a certain value which they would consider to be enough compensation. But what stops them from demanding irrationally high price for even petty violations? First of all, restitution amount cannot be so high that the aggressor loses his interest in even paying for it. Remember, the reason why he wishes to accept this restitution debt is because he either he wishes to rejoin civilization and regain his reputation, or he's afraid that the retaliation would make life uncomfortable and maybe even impossible. If restitution amount that the victim demands or the victim's agency's demands is too high, he might even lose that interest. Like if it's so high that he has to work his entire life and he still won't be able to pay it. This is why we have so many criminal fugitives. The state justice system offers nothing to the criminal, no chance at redemption or rehabilitation, and the justice that the state imposes appears to be so unjust that being a fugitive seems like a rational thing to do. So restitution amount would not tend to be irrationally high because it would not be in the best interest of the victim. If the criminal decides to be a fugitive, the victim will get no restitution. But what if the situation arises where the criminal thinks that the restitution amount demanded by the victim is really high, or that the detective agency did some frivolous expenditure to actually capture him and is simply passing the expenses on to him? Does he only have two options, pay the restitution or become a fugitive? Certainly him becoming a fugitive is not something both parties want, unless the criminal is incorrigible, in which case it's a matter of show of strength, and in anarchy such threats will be neutralized with minimum fuss. But is there no way for criminal to participate in this process and still not be subjected to irrationally high punishment? This is where the competition comes in. In matter of state, no one has the right to contest a state court's decision except an even higher state court. But the judgment of anyone in market anarchy can be contested by anyone, and there is no legal immunity. And there is so if the criminal thinks that that his punishment is disproportionate to his crime, he certainly has other agencies he can turn to, in which case a dispute will exist between the criminal and the victim. Only now is arbitration needed. If the criminal had accepted the demands of the victim and his insurance agency, the matter would have been settled and there would have been no need for an arbitration agency involved. And therefore no cost of arbitration would be involved either. This leads to another interesting conclusion, that because an arbitrator costs money and the loser of the trial would have to foot the bill, in this situation there is no incentive to prolong a trial or to make frivolous cases. If the criminal knows he has no case and knows that he cannot convince the jury that his crime is disproportionate, then he's not likely to file a case, because if he loses the case, his monetary losses would increase. Same is true for other side. The victim or his agency is less likely to demand an irrationally high punishment if they know that they are going to lose in arbitration and will have to pay for the arbitrator's service. Instead of gaining a high profit from restitution, the agency will end up losing a small amount of money to the arbitration agency. This way, everybody has an incentive to not file frivolous cases and to not prolong the case. Longer the case, more is the arbitration fees, and the more the loser has to pay. And in most of the cases, it is the loser, the person who expects to lose, that prolongs a trial. Compare this to the state court system, which actually incentivizes frivolous cases and allows cases to prolong because of their inability to calculate cost of arbitration, precisely due to the lack of competition and tax funding. Furthermore, the hierarchical structure of the state court system becomes merely a bottleneck for the justice to actually reach the victims. While in market justice system there is an incentive for a speedy trial, and every case is on a fast track because there is private money involved in prolonging the case rather than public money, which no one is accountable for. People usually try to say this the other way around, that we need a hierarchical court system because there needs to be a final arbitrator. But such a term is a misnomer when one considers that litigation costs money that the loser has to pay. So there will always be a final arbitrator, and cases will not prolong forever. It is just that there would never be a single final arbitrator. Others others say that if the victim and the criminal are unable to agree on an arbitrator, we need a final arbitrator that must be imposed on them so that peaceful resolution can happen. But this could only be called peaceful resolution in a very corrupted sense. Arbitration occurs when the two parties are in conflict and are ready to settle. If one party is ready for arbitration and the other is not, then no mythical authority of a final arbitrator will be able to get them to sit and talk. In such a situation, physical conflict would be impossible to avoid. What really would stop a war from breaking out uh, would be retaliatory force, and there is no reason to believe that such retaliatory force can only be provided by the state. A war is really not in the best interest of the other market actors. You wouldn't believe how many wars have been averted because of lobbying from corporations. I'm not talking about corporations that benefit from war, namely the military industrial complex, but those corporations that benefit from peace. If India and Pakistan were at war, Indian traders and corporations will suffer because of loss of business they used to get from Pakistan. The damage to their property on the other side of the border would be certainly high enough to warrant such lobbying. More well established the market relations are, less likely is the possibility of war. My understanding is that in most cases there will be a going rate of restitution, and those most cases won't even reach the arbitrators. The criminal who has been caught will accept the punishment because he knows that litigation would make things worse for him. Other special cases will reach arbitrators where the victim or the aggressor thinks that the restitution amount is disproportionate. In those cases, the arbitrators play a vital role in the market to determine the price of restitution. Law will be of a different nature in this kind of society. It will not be just a bunch of legislators imposing laws in a top-down manner. Under state law system, all judgments are to be given in accordance with the law. The aim of the state court system is primarily compliance with the law, whereas what the courts are needed for is conflict resolution to minimize unresolved conflict in society. We find that many laws in current system create conflict rather than resolving them. Those are not the kind of laws that will develop in a free society. In a free society, laws will be demanded by the consumers of the law. Law will no longer be the governing force of arbitration, but rather simply a pattern of arbitration. Libraries could form and have formed where these patterns will be studied to help newer cases. Justice will not be about using the legislative law to drive the case in your favor, but rather the aim would be conflict resolution. In a well-developed free society where this sort of system has reached more or less an equilibrium, we would find that less and less amount of force is actually needed for justice because aggression is rare and restitution is easy. Which is why when we will discuss past examples in part 4 of this series, we will find that some historical cases of private law society even lacked a permanent police force. Sure, and so I also actually need something for my throat. So anybody has any questions till now?
Not for me.
No.
Okay, then I will continue. Many values which can be destroyed or damaged by aggression are not only irreplaceable, but they are also non-exchangeable. That is, they can't be exchanged on the market. So no monetary value can be placed on them. Examples of non-exchangeable values are life, a hand, or eye, the life of a loved one, safety of a kidnapped child, etc. and yes, this includes rape. When confronted with the problem of fixing the amount of reparations for a non-exchangeable value, many people immediately ask, "But how can you set a price on a human life?" The answer is that when an arbitration agency sets the reparations for a loss of life, it isn't trying to put a monetary price on that life any more than is the insurance company when it sells a to $20,000 life insurance policy. It is merely trying to compensate the victim or his survivors uh, to the fullest extent possible under the circumstances. The problem in fixing reparations for loss of life or limb is that the loss occurs in one kind of value, which is non-exchangeable, and repayment must be made in another kind of value, which is money. These two kinds of values are incommensurable. Neither can be measured in terms of the other. The value which has been destroyed not only can't be replaced with a similar value, it can't be replaced with an equivalent sum of money, since there is no way to determine what is equivalent. And yet monetary payments is the practical way to make reparations. It is useful to remember here that justice consists of requiring the aggressor to compensate his victims for their losses insofar as humanly possible, since no one is expected to do the impossible. Even a destroyed item which has a market value which can't be replaced, for example, Mona Lisa painting, to demand that justice require the impossible is to make justice impossible. To reject the reparation system because it can't replace the destroyed value with an equivalent value is like rejecting medicine because the patient can't always be restored to as good a state of health as he enjoyed before his illness. Justice, like medicine, must be contextual. It must not demand what is impossible in any given context. The question then is not how arbitrators can set a price on life or limb. It is rather how can they see the victim is fairly compensated insofar as humanly possible without doing injustice to the aggressor by requiring overcompensation. End quote. Uh, that was Tannehill's on the question of non-exchangeable goods. I remember someone asked me this doubt that monetary compensation isn't always preferable. Proponents of state justice system argue that strict punishment is needed to deter future crimes, and that monetary deterrence cannot replace physical hard punishment. Yeah, that was you, Shikar. All the foregoing objections to a monetary system assume that it would not be sufficiently costly to deter aggression, or in other words, that it is severity of punishment which deters aggression. The untruth of this assumption should be evident from examination of such historical eras as Elizabethan England, in which punishments of extreme severity prevailed, including physical mutilation and hanging for petty theft. Yet, in spite of the great loss of value imposed on the criminals, crime rates were very high. The reason for this is that it is not the severity but justice which deters aggression. To punish the aggressor with more severity than his actions warrant, that is, to impose on him a greater loss of value than which is necessary to make him which is necessary for him to make reasonable reparations to the victim, is to commit injustice against him. Injustice cannot be a deterrent to injustice. The aggressor who is treated with such excessive severity feels, quite rightly, that he has been victimized. Seeing little or no justice in his punishment, he feels a vast resentment and often forms a resolve to get even with society as soon as possible. Thus, in dealing with aggression, excessive severity, as much as excessive laxity, can provoke further aggressive acts. And only valid answer to injustice is justice. Justice cannot be served by excessive severity or by taking revenge against the aggressor or by pacifism, but only by requiring the aggressor to pay the debt which he has created by his coercive action. Is Is revenge a rational act in the eyes of the victim? I can't make that decision. If you choose revenge over compensation, that is your choice. The market doesn't outlaw it. If your revenge is considered just in the eyes of the market actors, it will be allowed to slide through. But you can't really shoot a man who accidentally stepped on your garden. That revenge would be disproportionate in the eyes of almost any logical person, and that will be punished. But here is another problem with revenge. It is personal. No one else is going to take revenge for you, because justifying revenge is not exactly an easy it's not exactly easy, because proportionality has to be decided by an onlooker, and in case of death of the aggressor, it has to be analyzed without any inputs from the aggressor. It might very well be that the market institutions of justice will punish reckless acts of revenge that may affect their other clients. It might also be that for some very high, for some very heinous crimes, the market institutions revert to just revenge. But that becomes very unlikely. The public institutions, uh, that is the state, are able to take revenge from time to time on behalf of victim because they lack private responsibility. The same person who demands death penalty would never press the kill switch himself. He would have trouble taking this on his own conscience. He would be very afraid to do something as a private citizen, that which cannot be undone, unless he was approved or appointed by the state. Killing someone in the name of law, in the name of greater good, or because you were ordered by someone you perceive to be in authority is easy. The saddest part of statism is that people doing the killings today refuse to take private responsibility. They are able to hide behind the law. If you lost something that is non-exchangeable or irreplaceable, the market institutions cannot offer you anything more than what is possible. They can't replace those lost items, and neither can revenge. Revenge might seem rational to the victim from time to time, but the same is not true for others that have and when they have to take private responsibility for it. Now, murder. Andrew left, so actually his answer was coming up here. So, murder poses a special problem in that it constitutes an act of aggression which, by its very nature, renders the victim incapable of ever collecting debt owed by the aggressor. Nevertheless, the aggressor did create a debt, and the death of the creditor, that is the victim, does not cancel this debt or excuse him from making payment. In this connection, it is useful to recall what a debt actually is. A debt is a property which morally belongs to a person, but which is in actual or potential possession of another. Since the debt occasioned by the attack on the victim would have been his property had he survived that attack, his death places it, together with the rest of his property in the estate, to become the property of his heirs, or according to his will. In addition to primary debt owed to the estate of the victim, the aggressor also owes debts to all those to all those whom the victim's death has caused a direct or major loss of value, such as his family, even though such people may also be his heirs. But suppose a person who has no family or friends and no aggression insurance. Would the aggressor get scot-free just because his victim is of value, because his victim was of no value to anyone but himself and left no heirs to his property? The debt would still not be cancelled out. It is still there. The only difference is that it is now unowned potential property. In our society, such unowned potential property is immediately expropriated by the government as much as other unowned wealth. Such a practice can be justified only if one assumes that government or the public is the original and true owner of all property, and that individuals are merely permitted to hold property by the grace and at the pleasure of the government. In the free market society, unowned wealth would be belong to whatever person first went to the trouble of taking possession of it. in regard to the debt owed by the aggressor to the estate of his victim. This would mean that anyone who wished to go to the trouble and expense of finding the aggressor and, if necessary, proving him guilty before our professional arbiters would certainly deserve to collect the debt. This function could be performed by an individual, by an agency specifically constituted for this purpose, or by a defense agency or an insurance company. Insurance companies would be most likely to take care of this kind of aggression in order to deter violence and gain customer goodwill. End quote. Interest getting accumulated on his debt. Well, yes, certainly. Why wouldn't it? If yes, you have another question, follow-up question. Shikhar? Anyway, so I'll move forward. Another argument against anarchy is that because the government-less society would have no single society-wide institution able to legitimately wield superior force to prevent aggression, the state of gang warfare between defense agencies would arise. The gang warfare objection has been raised in regard to theories advocating a system of competing governments. When applied to any type of governments, the objection is a valid one. A government being a coercive monopoly is always in the position of initiating force simply by the fact of its existence. So it is not surprising that conflicts between governments frequently take the form of war. Since a government is a coercive monopoly, the notion of more than one government occupying the same area at the same time is ridiculous. But a laissez-faire society would involve not governments but private businesses operating in a free market. With this, we finish chapter 4. I hope I was able to explain the concept of justice. Okay, Shikha, are you back? So yeah, there would be interest in case of debt. If he pays the debt straight away, there probably won't be interest, but there would still be interest in the sense of time preference. So if I stole some money from you, you could not use that money by the time I had that money, right? So you would still be eligible for interest. So if you read the chapter, Morrison, if you read the chapter, the amount of money that I end up paying would constitute of a lot of different aspects. It would constitute not only the time preference, the interest due to time preference, but also the psychological damage I have caused you, and the original money that I took, and a host of other secondary, the cost of arbitrators and things like that will also be put into the total of what I am going to be charged, and the arbitrator will end up deciding what is going to be ultimately charged. So, I'll move on to chapter 5, the topic of crime prevention. Any question about this chapter, Morris and Linda Tannehill? So I think the greatest insight that this chapter 4 has provided to me is that first of all, it made it more clear how the restitution amount will be set, and second, it also made it clear why the state system of why the state system or court system gets really clogged up, and why court cases tend to prolong, and why it wouldn't happen in a free market justice system. So, if there are no questions, I'll move on.
I don't have any.
Okay. Justice is a concept that is considered after a crime has been committed. But what of crime prevention? We discussed private security, law, and then justice. But what about preventing crime itself? Does the state contribute in this regard, and how can a free society prevent crime? What sort of legal order works better in this regard? The Tannehills touched on this topic from a psychological point of view, where they said that only the justice can send the right signals to the criminals, not revenge. But Randy Barnett discusses these questions from an economic point of view in the chapter 5. If you remember, the accusation was that in a monetary-based restitution system, criminals would simply pay money to get off the hook, and there would be too much crime and not much prevention, not much deterrence actually. In a social goal, as a social goal, crime prevention is important, but should we accept a legal institution that promises crime prevention but ignores individual rights? Any failure to adequately define or respect individual rights in organizing law enforcement institution, any failure to adequately define or respect individual rights in organizing law enforcement institutions has three adverse effects. First, the example of community leaders disregarding individual rights in pursuit of goals thought to be socially desirable encourages the violation of rights by others in pursuit of their goals. Second, a principal benefit of respecting property rights, that makes possible a free market in goods and services with its unique ability to efficiently allocate resources. When property rights are overridden in pursuit of crime prevention, this vital social mechanism is unavailable to allocate resources in the most efficient manner. Finally, to the extent that we place security and the defense of a free society above individual rights, we may obtain the security we seek, but we are unlikely to preserve the freedom that makes security worth having. Another insight that Barnett brings is the contribution of the problem of commons to crime prevention. Property that is viewed as common does not have the right of exclusion. No person has the right to exclude another from exploiting a common property. Without this principle of exclusion, investors are less likely to invest in development of public property because they are less likely to have any ability to extract returns from it. For instance, if you bought a packet of chips on a trip with your friends, you will notice that the packet gets finished too quickly, because within the friend circle, the packet is considered commons. Now, your friends could have taken the chips from the packet in moderation, but then there isn't an incentive to do so. If you do not take the chips from the packet quickly, others will, which leads to everyone maximizing their own consumption of resource. However, if you had plates and distributed the chips from the bigger packet with your friends, the chips would last longer, because within the friend circle, no one considers it their right to take from what the other has been allotted. The chips in your plate is your own, and you have no right to exclude, and you have the right to exclude others from taking it from it. For this reason, commonly held resources tend to be overused and undermaintained. Barnett applies this concept of tragedy of commons to the goal of crime prevention. At least part of the problem of crime in streets may stem from the belief that the streets must be owned in common. The fact that public parks and streets are held in common adversely affects crime prevention in two important ways. First, when little incentive exists for individuals to commit their private resources to prevent rights violating conduct on so-called public property, there appears no choice but to create an inherently inefficient coercive monopoly to provide public police protection. Second, when property is owned and administered by a central government, constitutional constraints on the government's power to exclude citizens from using public property is needed to minimize abuses of power. Such unavoidable limitations on the proper management of public property can be shown to seriously inhibit crime prevention. Individuals are less likely to voluntarily pay for private security patrols to protect themselves or their children while they use the public parks and streets unless, as is sometimes the case, the provision of this service can be limited to those who are paying for it, which is why we do not find private investors investing in and improving crime prevention infrastructure in public places. Without such investments from the private sector, it falls on the duties of the government to provide such security in public places, which means taxes and intrusive government agencies. But as we have already discussed, practical accountability of government law enforcement agencies to the consumer will at best be indirect and at worst non-existent. Moreover, tax-funded government institutions appear to need no consent from the people among whom the property is actually considered to be held in common. Government institutions, therefore, face no competition in this regard. They are therefore plagued by the knowledge problem that we discussed in the previous broadcast. The lack of right to exclude also affects crime prevention. We need not admit into our house any person who knocks on your door, nor must you wait for a guest on your property to commit an aggressive act before you may ask that person to leave. Your house being your private property, you have the right to exclude others from entering it. Government, however, is not the property owner of commons. It has certain constitutional restraints on this governance, and for good reasons. Government, being a coercive monopoly that declares its control over all the streets, cannot act as a private property owner. That would be against the democratic principles but because of this lack of right to exclude from public property, we find that certain social problems arise. Governments cannot withhold someone from entering public parks or streets on mere suspicion, like private property owners can. This Randy Barnett calls the dilemma of vulnerability. It is a dilemma because in a status society we really have only two options. Either we advocate that the state does not violate its basic democratic principle and allow anyone to enter our public streets, or we advocate a tyranny of government without any checks and balances that competition provides so that it may provide security. If you demand security from the government in public places, you demand that they treat the public places as their own private property. But if you restrict that ability of government, you become vulnerable to street crimes because of the inability of the state justice system to deter crimes. We can see that this dilemma of vulnerability in Delhi, where many CCTV cameras will be installed in public buses and streets. It is usually thought that libertarians choose liberty over security, and this is partly true. Uh, Libertarians do not want the entire public property to be under government CCTV cameras, but we also are not advocating that we do nothing. We are advocating that the field of security must be made open on the market and the property norms must be decided on the market rather than by the government. Suppose there was a competition in bus services, surely there would be bus services that use CCTV cameras and those that don't. Those that do use CCTV cameras would be less likely to abuse them when there is competition. But because of the inadequacy of Delhi police in preventing crimes, the citizens of Delhi are now likely to trade their liberties for security. And sure enough, all the political parties in Delhi promised to do just that. Any questions till now?
Not really.
We discussed before the concept of crimes being committed against society. We saw that this kind of thinking is fallacious. However, this fallacy has had drastic effects on justice and crime prevention. For starters, when you imprison someone, you take away their ability to actually provide reparations to their victims. Victims of most serious crimes and their families are thereby twice victimized. Once by the rights violator, and again by the enforcement agencies that require victims to participate in some considerable risk and cost, at some considerable risk and cost, while denying them any effective ability to obtain reparations from the offender. However, the system of imprisonment did not come about by accident. When most of the crime is committed on public property, which becomes safe havens for criminals, the state now thinks about keeping known criminals off the street. Excluding them from the vast majority of public spaces is nearly impossible with resources the state has and the lack of infrastructure due to tragedy of commons. So the state imprisons them. Imprisonment is an act of complete deprivation of liberty, which means that one must be proven guilty beyond reasonable doubt before they can be subjected to it. And because there are no other viable path to justice available, criminal sanctions for many offenders admit of only 2 degrees of severity: onerous or virtually non-existent. Either the criminal is completely free to commit more crimes, or he is imprisonment under harshest conditions. Barnett summarizes how the state does crime prevention as follows. Step 1. Start with public streets, sidewalks and parks, where every citizen must be permitted unless proved guilty of a crime. Step 2. Rely on the inherently inefficient public bureaucracy to catch, prosecute and try those criminals against whom enough evidence of guilt exists. Step 3. Should they be convicted, subject them to the dangerous and sometimes uncontrollable setting of public prisons to prevent them from engaging in further misconduct. Step 4. Periodically release most of the prisoners back into the community and then return to step 1 and repeat the cycle. Each step follows from the preceding step, and each step unavoidably leaves considerable room for criminal conduct to thrive. If we set out to deliberately design a system that encouraged criminal conduct and nurtured hardened career criminals, we could hardly do a better job. Contrary to this, crime prevention in a private society is much more decentralized and as compared to the state society. Under the state system, a criminal either has the right to be on all public properties or he is in prison. Under private societies which have the right of exclusion, communities will be more easily be able to exclude or ostracize someone. With the right or to exclude, crime prevention will become a private matter. There is also a matter of black markets, which are formed when the state outlaws victimless actions and it considers as crimes. As Bastiat says, when law and morality contradict each other, the citizen has the cruel alternative of either losing his moral sense or losing his respect for the law. There's still some portion of chapter 5 left, but this presentation has become too long. I'm also not prepared for that portion. I will cover it because it has some interesting similarities between what could be called international anarchy and anarchy in general, and how autonomous nations are able to resolve conflicts, especially conflicts between their citizens by pre-agreements. Basically, the logic that we need, the logic is that we need, if the logic that we need a unitary legal system is true, then we should also need a super Supreme Court with international police to govern us all, and that certainly seems absurd, unless you are Bill Gates. It is an interesting read, but I will be leaving that for later. I initially wanted to do chapter 4 and 5 separately, but I thought it would be interesting to have the insights of Tragedy of Commons done together with the chapters on Tannehill's. So, anything else? This is it from my side. Nathan, you want to add something?
Yeah. There is a small part, the donor's problem. Okay, like there might be some old people, or some person who want to go into an isolation. I think there is two folds to it. One, who would claim their property, right? If it's a natural death, the property, like in our society, it goes to the government. In other cases, it would be homesteaded, right? Because there is no property owner left anymore. So next one who homesteads it, it belongs to them, right? The other problem is like it's one problem is like what happens if a loaner has not subscribed to any agency, right? Like he has not taken any insurance, he has not availed for any protection agency, he has not subscribed for protection or justice. Whose responsibility it is to see that a violent criminal has should be brought to trial. The problem here is like when I mean we have to investigate like what happens if a person who doesn't have insurance dies. Should he be paid? Should his gains be made to paid some compensation or something? Out of humanity, yes, it's possible, but I think that's some kind of negligence on the part of that loaner or whosoever it is. It's like it's his choice, right? He didn't go for it. The threat and the risk of getting murdered or being a victim of a crime was already there. So this is
Yeah,
something
I mean, yes, I mean, there both sides on the market will be always be true. If there's no one really to care for him, there's no one to see the case through. There really is a little incentive for anyone to even know that he has disappeared. Uh, this is certainly sad, and it is true even under the state, right? I mean, if no one reports him missing, the state doesn't find his body, and nothing happens. The state even doesn't know he's dead, and no one actually
yeah,
does
but
anything.
but because see, you might have read in the newspapers that there are many old people, right? Childless couples, old people who would have died or been killed by their
Yeah.
servants or stuff.
So,
Yeah,
so what the Tannehill's right is that, according to libertarian principles, or like according in a free society, anything that is unowned is ready for homestead, right? It's ready for expropriation by anyone who cares to take it. So suppose there is a murderer who murdered someone who is a loner, and he goes away. He goes away into hiding, and someone. So what they say is that anyone who takes the incentive, the entrepreneurial risk to track him down, present him in front of arbitrator, would be able to profit, right? He'll be able to extract restitutive debt from him, and that debt will, because there is no victim to claim for it, that debt will now come to me, because that restitutive debt is now unowned property, and
yep.
so it will actually be incentive uh, for anybody really to track down that murderer who murdered this loner, and to extract restitution from him.
See,
So
that's part one. Okay, the part two is also like why should we give it to, like, why should we consider that uh,
uh, well, because
for it, right? There is like each and every one, each one of us knows that we have a threat to our life, right? There is a risk always involved. It's a factor of our life, right? It's a fact of our life. So if we are not taking any subscription from protection agencies or from for or claiming insurance in a free society where we are free to make those choices, why should it's something which is something that we have agreed to that risk, and we were okay for getting murdered or whatever it is. So it's actually our fault that we have not taken any kind of
I wouldn't say that, because insurance is not necessarily a requirement for this kind of system. Because and the last time I also discussed this, I discussed it stepwise, and insurance is needed because suppose like someone has stolen everything that I ever had. Now I don't have any money to hire a detective agency, or a recovery agency, or even an arbitrator. I have no money at all. Everything has been stolen. In that situation, insurance becomes my boon, because the insurance company will now, according
yes.
to their contract, will track down the criminal and try to extract restitution from him. But where were we exactly? But
But if you have a valuable thing and you have not insured it,
No, yeah, but like so, insurance company is simply hiring other detective agencies and other
that is
recovery
what.
agencies for you, but it doesn't mean that no one else can hire them. So so even if I am an entrepreneur who does this exactly this, that he tracks down murderers who no one's going after, tracks them down, brings them to justice, and take ownership of the restitutive debt. I will be able to hire services of detective agencies to track him down, or the recovery agencies to recover restitutive debt, and I would be able to do all of those things, even if that person didn't have insurance, the victim that didn't have insurance. So I don't think that insurance becomes a requirement in such a society. I mean, most people would
If you
preferably
don't
have.
have the
Yeah,
free
if you
riders,
don't, yeah, no, if you don't have it, you're obviously at a disadvantage. But I wouldn't say you are a free rider. I mean, people don't take insurance for a lot of things. I mean, I have lots of properties I'm not taking insurance of, and
they just
I'm not going to go and demand an insurance company to track down the victim. I can't do that. Insurance company is not the state, and
but you already have subscribed to, like, you already have an agency, right? You have an institution which is going to do it for you, so you're not worried about insurance or life insurance and stuff, right? Because a lot of things have been covered for you already. For example,
you're talking about state, right? No, what I'm saying is that insurance, uh, and when the society is evolving, insurance might just be a luxury at that time, and then it might seep into the society. And people think that the insurance company will prop up as soon as the state dies. That is not going to happen. The system will take time to come up, and while it is doing so, while people are accumulating capital for this particular task, people are not going to have insurance. I won't have insurance because there will be no insurance company providing this kind of thing, but there will still be private detective agencies that I can hire to track down my aggressor, and there will still be private defense agencies that I can hire to get the only thing that insurance companies provide to me is that I don't have to do that hiring with my own money anymore, because I've been paying premiums to the insurance company. So
but you will
I have an insurance of making those payments.
yeah, but you will have a subscription, right? Because if there is
I'm
any
saying
state
that I mean the society is just developing right now. Nobody is providing insurance for this kind of job. So where will you go for insurance?
see, insurance companies are always,
I mean, we
see,
assume
my
that
point.
insurance companies will definitely prop up, but that depends on how much capital we have accumulated, right? In the caveman society, there weren't any insurance companies, but they were still
Society.
they were still it could still be possible that someone went and recovered something that has been stolen. You don't need an insurance company for that. Insurance companies make the life of a particular person easier. It provides insurance against aggression,
Will
and
be
it makes the insurance company's responsibility to bring the aggressor to justice rather than yourself. It makes your life easier, but it's not a requirement. That is
see,
what I'm saying.
insurance always deals with risk, and you will have uncertainty which is dealt by the protection services, right? Like,
Yeah.
in every society, you're supposed to, take care of yourself. That is the first premises of a free
Yeah,
society.
yeah. So no, I'm not saying that someone has to take care of you. Uh, that is not what my argument was from the start. So
You have a free riders problem, right? That is the problem. You have a free riders problem where everyone has to, like, it's your property. You have to take care of it. That is the first premise of it, right? If it is your property and you're not taking safety precautions, the insurance company is not supposed to pay you anything, isn't it?
yeah, yeah, that's totally true. So if I'm not subscribed to an insurance company, I don't have the right to go and demand some sort of justice from the insurance company.
Exactly. So this loaners or these people who
No, I didn't
didn't
say
go.
that it is the right, they have the right to justice. I did not say that someone must be forced to provide that justice.
Yes, so that is the thing.
I
Like
did not
here,
say
the
that. I
government.
said that it will be nobody is being forced. I don't know if you misunderstood, but nobody is being forced to go after the person who doesn't the aggressor of a person who doesn't have any insurance. I did not say that. I said that it might still be profitable for someone to go after that aggressor.
See, there will be another agencies or institution which I see will crop up in a private society. It will be the caretaker's home, like orphanage and old age.
Hmm.
Agencies where you have caretakers
Yeah,
who will
that is
go in.
of course another answer for this. Yeah, so you're saying that there'll be specifically agencies uh, which provide you safe
Yeah,
havens for
grocery
people.
services or some kind of healthcare, like bringing in medicines or fetching medicines from the from the city or somewhere. You have certain services which is
That
coming.
that will suddenly crop up, and in that case, if you're murdered, it will be.
It's already there in developed cities like in Mumbai or somewhere where you have medicines being delivered home delivered to old people, and there are regular checkups like doctors. You subscribe to a doctor or hospital. They do a health checkup at your home, collect your blood test and stuff. You have cemeteries where you have when they die they would be buried here and everything. Like all those contracts are there. So I think those kind of agencies will.
Yeah, those kind of agencies may also crop up. Mithun, have you disconnected or something? Okay, he's got disconnected. Okay, Shikhar, Bhavin, any questions?
Yeah, not really. I was just thinking it would be a really good, time for bounty hunters.
Yeah, yeah, it will be a really good time for bounty hunters. Yeah, the
Okay.
bounty hunters are actually do exist, I think, don't they? I mean, even the state police department. I've heard of cases that they give out bounties on particular criminals, and bounty hunters, authorized and licensed bounty hunters, of course, uh, have the go track down and claim those bounties by capturing those criminals and bringing them to the state police. So yeah, bounty hunters is also a job on the market, and the only difference is that what I'm arguing for, that is essentially a free society. Bounty hunters will be responsible for their actions. It is not like if you capture someone for an offense that he did not commit, then hunter will also be liable.
Yeah, okay.